Assalamualaikum warahmatullahi wabarakatuh. I am Amira and today I with my group members which is group 9 will present about legal issue in pre-employment testing. My group members are first Nurin Shazwana binti Abdullah, matric number 1180136. Second, Nurul Ain Izzati binti Mansur, matric number 1180137. Third is Nur Amira Murshida binti Hazri, matric number 1180148. Fourth is Putri Nur Balkis binti Shahrul, matric number 1180149. And fifth is Farah Tasnim binti Muhammad Basri, matric number 1180150. What is pre-employment testing? According to Carrigan 2007, pre-employment testing has become one of the fastest growing tools used to select successful employees within organization. According to Skinnerer in 2001, pre-hire testing is an effective risk management tool that has been proven to significantly reduce turnover and improve productivity. Example of tests in pre-employment testing. First is cognitive test. According to Carrigan in 2007, this test is not only measure learning aptitude, but it is also test applicants' ability to apply learned concepts to new situations, workforce, and work activities. Second is personality test. According to Carrigan in 2007, personality test will measure A. Conscientiousness, B. Stress coping skills, C. Anger management.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Farah Tasni binti Muhammad Basri. My matric number 1180150. So I will move to issue in pre-employment, which is discrimination of Greeks versus Duke Power Company. Okay, for this issue, the plaintiff is Willie Greeks, an African-American employee of Duke Power Company. He filed a class action on his own and also on behalf of several fellow African-American employees. Greeks challenged Duke's inside transfer policy, requiring employees who want to work in all but the company's lowest paying labor department to register a minimum score onto separate aptitude tests in addition to having a high education. Greeks claimed that Duke's policy discriminated against African American employees in violation of Title VII of the 1964 Civil Rights Act. Under Title VII of the Civil Rights Act of 1964, it is unlawful for an employer to refuse to hire any individual or otherwise discriminate against any individual with respect to his employment because of race, color, religion, sex, or national origin. Okay. On appeal from a district court's dismissal of the claim, the Court of Appeals found no discriminatory practices. But after noting that Title VII of the Act, the court held that Duke's standardized testing requirement prevented a disproportionate number of African American employees from being hired by and advancing to higher paying departments within the company. The court concluded that the subtle illegal purpose of these requirements was to safeguard Duke's long-standing policy of giving job preferences to its white employees, ever since that decision tests need to be relevant and valid when given in the employment context. So I will pass to my friend.
Neglective hiring. Employers choose employees in a careless way. When the employer is not careful in such matter, the employer will get the employee in trouble. In this case, the employer will be blamed and will have to take responsibility if any problems occur. An example that can be shared is if an airport takes a security guard who has a criminal problem, then the security guard steals or commit to attack on a customer, then the employer should be responsible for the incident. Liability for negligent hiring depends on whether one places someone with a negative background into a position where it could be argued one should have foreseen that the individual that was hired posed a threat to others. To protect themselves from reckless recruitment claims, one should conduct a suitable background check on the applicant. Employers are most at risk of recklessly claiming if a person's business involves a large relationship with a third party such as a customer. Think about what the employer's responsibilities are and what dangers might arise from giving a position to someone who is potentially dangerous.
Assalamualaikum warahmatullahi wabarakatuh. My name is Putri Nobalkis. I will continue with solution in issue discrimination in pre-employment. First is a right to privacy. As an employee, the Constitution right to privacy protect public employees. The employer have to protect privacy in question answered by a pre-employers in test, for example, question about a sexual preference, religious or political view. With this privacy, the towards employee discrimination will not exist. So, second is the solution is Civil Rights Act of 1964. It's lawful for an employer to refuse to hire any individual or otherwise discriminate against any individual with respect to his employment. So, employment can use this act to protect themselves from discrimination in pre-employment.
Okay, in conclusion, pre-employment testing is shaping the way employers hire qualified, successful, and performance-driven employees. Pre-employment testing strategies and methods, coupled with a comprehensive pre-selection or hiring process, will ensure that the most qualified candidates are chosen and not overlooked in today's dynamic and ever-changing workforce. Understanding the testing guideline is necessary in order to eliminate the likelihood of unintended issue in the pre-employment testing. Many employers think properly used and administered formal tests can be beneficial to the employment selection process, but relying too much on a score isn't a good idea. The best hiring decision consider many aspects of a candidate's personality, behavior, and skill. It's better to use multiple tests developed and validated by experts. View the result as one of many dimensions that can influence the hiring decision. Okay, that's all from us. Thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.